In this video, I'm going to be analysing the arrest of Reckless Ben. In doing so, I'm going to have to look at key points in Officer Sumbot's investigation. If you know the case well, you can jump ahead, and if you know nothing about this case, then it starts with Josh Johnson. Josh Johnson wanted Reckless Ben arrested.
I got a call from my boss, and it was like, how do we get them arrested? How do we get them arrested?
And after Ben arrived in Utah to serve Josh papers, Josh called the police on multiple occasions, suggesting different charges.
What about taking a UPS driver? Is that illegal? So Provo apparently has a warrant for him. What constitutes harassment here? Is that like a misdemeanor? Not a felony, huh?
The post office will, because it's a federal crime.
Eventually, someone he knew sent him the stalking statute.
That's what Ammon, the CEO of Bricks and Minifigs, said stalking was. So he sent that to me.
And after that, his phone call to the police was markedly different.
His name is Ben Schneider. He's stalking my house. Will you come to my house, please, and come get them? I'm not going to have stalkers. They're walking up to the window, taking pictures inside the house, scaring my wife, scaring my kids. I'm tired of these guys stalking me. Like, why can't we do stalking charges?
Responding to this call, Officer Sumbot headed straight to the car where Reckless Ben was sat. When there, Reckless Ben told him he was there to serve Josh papers.
We have to serve him legal papers, so we're just waiting for him to get home so we can serve him.
Then, Officer Sumbot walked around the house to find Josh telling the same story he told 2 days ago, although the story has noticeably evolved since the first time he told an officer.
He's hired this Reckless Ben, this crazy YouTube guy, to come and harass us.
So he's hired this YouTuber. His name is Ben Schneider. He's Reckless Ben. To harass us, to stalk us.
On being told that Ben is there to serve papers, Josh tells Officer Sumbot to go get them.
The kid who's in the car right now.
They're fake. Go get the papers. They're fake.
You okay if I give these papers to him?
Yeah, for sure.
Okay.
On returning with the papers, Josh tells Officer Sumbot that he has checked, there is nothing filed, and he will not be accepting fake papers.
Are you okay if she just gives you the papers so we can just get
Have
her?
you looked at the papers?
It looks like it's just instructions on some kind of Oregon claims court, civil court.
I've talked to the Kaiser Police Department. There's nothing filed. So no, I'm not accepting service from him.
Okay.
Absolutely not. It's fake.
At this, Officer Sumbot returned to his car to read the stalking statute at length. There he read that Ben would not be in violation of this act if he had a legitimate official or business purpose. On returning, Officer Sumbot said he was willing to work through stalking charges, but Ben saying he's serving papers puts him in a bit of a bind.
No. I want him for stalking.
Okay. That's something I can work through, but for right now, you want her trespassed?
Yes. That's all you can do.
Right now I can screen charges, but with them saying they're trying to serve papers, kind of puts me in a little bit of a bind. I understand you have a history with...
They're fake.
Okay, I work in treaty law and regulatory law. I don't tend to work in United States criminal law, so I'm going to rely on an expert. In this case, America's attorney. Please check his channel out sometime.
2 or more incidences.
Good for suspend. Yeah, that's something I'm more than willing to screen.
When he says screen, what he's saying is he's got to go talk to leadership, probably including the district attorney, to find out if they have the facts necessary to support a claim like that.
Having told Josh he had no intention of arresting Ben on the day, Officer Sumbot returned to Ben to accuse him of not following the court process and not having a proper process server.
Go through the legal process, find an actual process server.
She is an actual process server.
Do you have any any papers that show that you're a process server?
So anyone can be a process server. You have to be 18 years old, and you have to be not affiliated with the case.
After Ben stands his ground, Officer Sumbot returns to Josh, who wants the process server arrested.
I want her arrested for impersonating the process server.
So
He also gets his boss on the phone, who reiterates that there are no outstanding cases.
No lawsuits have been filed against us, against Josh and his entity, or against any of the parties that he's claiming.
Officer Sumbot then returns to his car and looks up the statute for the process server. He then looks up the statute for the stalking again, and then looks at something that has never been mentioned: targeted residential picketing. To reduce the risk of a wrongful arrest, police will look to add a second charge. And in concluding his investigation, Officer Sumbot confirmed that the papers were real.
Okay, so the defendant needs to be served with papers before the case will, start.
He then returns to Josh to tell him their plan is to kick Ben out, that they are going to screen charges, and Ben's case was genuine.
We're going to kick him out of here. Again, we're looking at some charges, but we're just kind of working through. It looks like this is a real case. It just hasn't gone to court.
After which, Officer Sumbot proceeded to where Ben was sat. There, he and another officer accused Ben of targeted residential picketing and straddling the line of stalking.
Right now, you're straddling the line of what we call stalking, okay?
But we're not stalking. We're here for we're doing what the court tells us. Isn't that
called residential picketing?
It's
a Class B misdemeanor.
You told him
And
what we're
putting
here
out
for,
signs.
Right? You told him what we're here. We're here to serve him papers.
Right now, you put up a sign, picketing sign, up right in front of his residence.
Including that this sign is a picketing sign. So let's do this one really quickly. Right, in Thornhill versus Alabama, 1940, the Supreme Court said that the term picketing was too vague, that it must be explicitly defined and narrowly defined. The Supreme Court came up with their own definition, which was patrolling, which they said was standing or marching. And in Labour Board versus Fruit Packers, the Supreme Court asserted that picketing was speech intertwined with conduct, and it was the conduct that could be regulated. So all we have to do is look at the definition of picketing in the targeted residential picketing statute. The first thing that stands out is standing or marching, the traditional Supreme Court definition, and apprise vocally, and that's it. There is no more conduct listed in this definition. Ben was sat in that car and only opened the window to speak to the police. This is what a picketing sign looks like. It has a pole going through it to allow you to hold it while you're standing or marching, while this would be a yard sign designed to be pushed into somebody's yard. The conduct around self-standing signs can be found in other parts of the Utah Code, just not in the picketing definition. They may as well have pointed to that sign and said it was a murder sign and Ben was guilty of murder. Now, if you believe this is a communication as part of the stalking statute, at least you're reading the text. But that sign is not a true threat. It is in a public forum, and therefore it is covered by the First Amendment.
We're here for a legitimate business reason.
On the scene, Ben demonstrated that he had read the stalking statute. And when Ben stands his ground, Officer Sumbot returns to the car when he looks at the targeted residential picketing statute again and the stalker statute again. Officer Sumbot then leaves the car and Ben is arrested. The charges are for stalking and targeted residential picketing. But the story doesn't end for the police there. They have an affidavit of probable cause to write. Officer Sumbot had held off arresting Ben all day because of this one section, and now he has to explain it to the court. So let's see what they said. I asked Benjamin if they had been knocking on the residence. Benjamin replied no and told me they were trying to serve the victim legal papers. The victim's doorbell camera shows the female coming up to his front door. I asked Benjamin who they worked for. He told me that he worked for himself and that the woman was there to serve the victim papers. It goes on. I explained to the victim that the individuals were trying to serve him civil papers. The victim responded that he did not want them because he believed they were fake. I spoke in more detail with the victim and the victim's boss, who both reiterated that there were no court cases open involving the victim or the company the victim worked for. And that's it. That is as much as they say. There is absolutely no mention of looking into this and finding out that they are real papers. They start with Ben claiming he wants to serve papers while implying he's lying about the process server knocking on Josh's door. They then go on to state Josh did not believe the papers were real because he had checked and there were no open cases, and this had been corroborated on the scene by a third party, his boss. Worth pointing out, statements the process server made, corroborating Ben's story, were excluded. As far as this probable cause goes, she is mute, and is only ever referred to as woman. A judge reading this would assume that the papers were fake, or the veracity of those papers were unknown at the time of the arrest. And they are not supposed to put discredited information into those affidavits. The only references to papers after that is Ben saying that Josh wants him to sit outside to serve him papers, and Officer Sumbot saying you need to find another way. In this false version of events, Josh isn't accepting the papers because he believes they are fake, but he knows they are real, and he knows that a small young girl wants to serve him papers. And since a reasonable person wouldn't be afraid in those circumstances, you could argue the police hid two material facts for the price of one. Now, this is called reckless disregard of the truth. Now we have all the body cam of Sumbot. We know he looked at the legislation twice. Both times he concluded he didn't want to charge Ben. He even articulated the reason why he preferred to screen charges. By the time they arrested Ben, they knew very well that the papers were real, but that clarity on a material fact was missing from the affidavit. And that's where I have a problem. I don't do criminal law. As far as I understand the Utah law, they've committed a second-degree felony. Where I'm going wrong? I don't know. Would there be a Frank's motion for this kind of affidavit? To be honest, I don't know. I do believe the American attorney's right here.
Serving legal process is a legitimate purpose. Showing up to serve papers in a real lawsuit is the opposite of no legitimate purpose.
As far as reckless disregard for the truth is concerned, it doesn't matter. I'm fairly sure Officer Sumbot has said everything he needs to say on camera to lose qualified immunity.
With them saying they're trying to serve papers, kind of puts me in a little bit of a bind.
But since his name didn't go on the affidavit, who's on the hook for it? I don't know. And what about the fact that there's a separate charge there? I don't know. I do know there's no probable cause for targeted residential picketing. It says they found a sign and it had stuff about Johnson on it. So what? It's a time, place and manner regulation in a public forum. It has to be content neutral and it has to be narrowly tailored. And nothing Ben is doing is within that narrow tailoring. They could have removed the sign under the city ordinance in a content neutral manner. Instead, they continually refer to the content of that sign.
You cannot be putting up signs,
Why
AI
not?
photos of his face in
Why
front
not?
of his house with information like that.
And absent of him doing anything that is in that regulation, we must assume he was arrested for the content of the sign. Although this was clearly not a federal crime, because Ben was never picketing. Now, I've heard online that there was a process server, and therefore Ben didn't need to be there. And if he didn't need to be there, then he didn't have a good reason. But even if the judge did decide that, that's not the end. The police clearly thought that delivering the papers was a legitimate reason. As far as I can tell, from all the falsehoods given by the chief of police, only one of them does not track straight back to an incident report.
The court confirmed that the case was indeed legitimate, but that papers had already been served.
The Supreme Court has consistently held that an enactment is void for vagueness, that a person of ordinary intelligence can read those laws and know what is prohibited. So consider that the officer thought it was a problem, that the officer asserted that he preferred to screen the charge, that he stacked the charge, that the police omitted material, that the chief of police falsely claimed the papers had already been served, and then on the scene showed he'd read the law and that he'd interpreted it the way that he did. How could they have all got it wrong and it not be vague? I don't know if there's an example of vagueness being proved by police corruption, but there's always the first time. And for me, coming from a regulatory background, this does look vague. But this law, making a false or inconsistent material statement, that doesn't look vague. If you make a false material statement under oath or affirmation, that is a second-degree felony. And if American Fort Police didn't commit that felony, I'd love to hear the defense.